Thank you all for joining Catherine Wilson and myself, Cressida Courtney, at Goldhawk Associates for our online employment law update. For those of you who haven't met with Catherine, she's Head of Employment Law and partner at Keebles law firm. Goldhawk Associates have been extremely pleased to work with her previously to run breakfast seminars to update on key issues and topics with our clients. Most of you, I hope, will be aware of us, Goldhawk Associates, but having recently expanded, we do now operate in a number of different sectors in the professional services market, including finance, public practice, HR, technology, sales, operations, and administration. I hope everyone's adjusting well to all these current challenges we're facing. Your roles in HR, no doubt, have and will be greatly valued through these times, and as we come out of lockdown and see the reality on how the pandemic has affected our businesses. So over the next 30 minutes, we're delighted to have Catherine provide us with some professional advice, which will support you through effective business continuity and guidance on the options open to employees post the immediate COVID-19 lockdown, including redundancies, layoffs, and salary reductions. I've also collated questions sent to me by some of our participants today, which I will then put to Catherine. If anyone attending today has any questions as a result of what's being discussed over the next hour, you're able to type these as we go along on the Q&A icon at the bottoms of your screens. I will then cover these off at the end. Lastly, you should be able to view the PowerPoint slides throughout, and these, along with a recorded version of the webinar, will be available to view on our LinkedIn page for anyone that wants to revisit or who has missed today's session. So we have a good agenda ahead of us. Let me now hand over to Catherine and the first slide.
Thanks, Cressida. Hopefully, if we have the next slide, please. I feel very much like I'm on one of these sort of government press conferences, actually, so forgive me. I think it's fair to say that we're living in very challenging times, and I'm sure that when we were talking about running our next breakfast seminar in March, we never thought it was going to be quite like this. I think everybody has talked a lot about furlough in the last couple of months. Before that, I think furlough was something they did if you were an Indian civil servant, you were furloughed back to England. We know that furlough started effectively in the middle of March, and we were it basically backdated to the 1st of March, and it opened for business on the 20th of April. And so far, so good. The HMRC site didn't crash, and we understand that a number of payments have already been made from about the 30th of April. I think the scale is important. And when we look at the focus of this talk, which is going to be on life post-furlough, not sadly post-COVID-19, but certainly post-lockdown, we can see the scale of the challenge. I think that the estimate at the moment is that it's 6.3 million jobs and 800,000 companies have applied for furlough. And those of you who can see the slide will see the sort of coffee shop. And I think the intention originally was that it would be aimed at smaller businesses who, like cafes and pubs, were effectively closed down almost overnight. In reality, of course, that isn't quite what happened. And so, for example, if we look for Transport for London, they've furloughed 7,000 staff at a cost of £15.8 million per month to the taxpayer. British Airways were even more successful, one might say, furloughing 30,000 staff, as well as coming up with a separate deal to vary contracts to the extent of 50% of salary for pilots for the next 2 months. So pretty drastic changes. This is not without controversy, and we've already begun to see in the media and the certain economic press that the perception that this furlough scheme may not be quite what's required. And certainly there has been a lot of controversy about the scale of furlough and the fact that businesses that hitherto were able to pay their senior executives excessive salaries, one might say, certainly in excess of £1 million a year, are still furloughing staff. Probably one of the reasons why Victoria Beckham, and we searched high and low for a picture of her smiling, but she clearly doesn't smile, was that she decided against furloughing her staff, preferring to use her £334 million personal fortune for the same process. But this, you'll be pleased to know, is not a talk about furlough. We're going to look at what life is going to be like, the so-called new normal. It's quite clear, and I think government policy has made it even clearer this week, that whilst they wish to encourage people to do the right thing, to stay at home, etc., and preserve confidence, there is clearly a cost to all of this. And in particular, I think it was the Chancellor who said that whilst there would be no cliff edge, we can expect the furlough scheme to come to an end. Quite how it's going to come to an end, I think, is a moot point. It's always quite interesting doing a talk a few days before a government announcement. Obviously, big health warnings. Some of the stuff that we're going to cover may in fact change. What I think we can tell, though, and what we should be planning for now is life post-furlough. So you'll see on the slide, which hopefully is visible to everybody, that there are various options. One is the return to normal option. One is, how do I reduce payroll but don't make redundancies? How do I end furlough and bring employees back to work on reduced hours and pay? How do I bring them back to work on the same hours for reduced pay? A lot more unpalatable. What about unpaid or part-time leave or sabbaticals? And then at the end, redundancies and headcount reductions. And I think we have to be honest with ourselves that there will be a number of redundancies and headcount reductions which flow out of this, whether furlough continues until Christmas or whether furlough ends in July. Return to business as normal, the easiest but most expensive option. Question here, which we're already beginning to see, is how do I bring somebody back? What did I say about notice in their furlough letter? Most people didn't say an awful lot. Did I, for example, say that they were able to work for other people? Did I exercise any control over what work they did? If I have somebody who works Monday to Friday for me and is furloughed and then takes a weekend job with Tesco's, then that clearly is a lot less of a problem than somebody who's decided to do a 0 hours on demand contract. So again, need to look back to the furlough letter. There is no prescribed mechanism. There's no 1 week or 4 weeks, certainly not a week's notice, but we would suggest a minimum of 48 hours notice. The other point to bear in mind is that there is this 3-week minimum furlough period, and this is a question that I think we come back to because it's been put in already. The minimum period is 3 weeks. If I have one individual who is absolutely crucial to maintaining one piece of equipment, and I need to bring that person back for a day, then they come back for a day, they're de-furloughed, as it were, they're paid normally by the business, no claim is made, they then go back on furlough. But the 3 weeks still comes into place. I think I've also put on the slide this question about what happens to the coronavirus jobs retention scheme. Seems pretty clear that once we know what's going to happen with that people will start looking at giving notice to return, depending upon when it is, from either the start or mid of June. So it is something that's really something we're going to have to consider in the next few weeks. But as I say at the top, the easiest but the most expensive option. We won't have a straw poll to think about how many of us here feel that that will apply to our own business. Yeah, reduce payroll costs without making redundancies. Now, we know that furlough has a big bonus, which is that 80% up to the cap of 2,500 is paid for by government. But it does not have all of the solutions. And there are a number of clients who have decided not to actually participate in the scheme. And certainly when the value in the scheme reduces, let's say it moves to, say, 50%, I think we can expect a slight deviance and diversion by certain businesses. It's possible to extend furlough without the benefit of government grant. If you're not taking the government grant, you can help yourself. If you're not taking the government grant, then obviously you can do other things, such as you can expect the individuals to pay for you and work for you during that time. So what I mean by that is at the moment, it's an all or nothing. If, however, you are paying the money yourself, then at that point, you have a lot more control upon it. Again, of course, we're talking about with agreement. We know that people were not designated furlough without their agreement. That would apply to furlough without the benefit of the government grant. Could therefore trigger collective consultation requirements, which would apply if, for example, we thought 20 or more of our individuals would refuse to be extended. So far, we know that anecdotally at least, that the number of individuals who declined to be furloughed was very, very low indeed. Query whether or not that will continue. The second point I've made on our slide was before we had furlough, we were beginning to look at what alternatives were also available. And for some clients, particularly in the industrial sector, at that point, we know that they already had contractual layoff provisions. If you don't have a contractual layoff provision, of course, you can still try and agree that with your employees. And again, some individuals may prefer to be laid off with their agreement than actually made redundant, particularly at a time when the job market looks particularly uncertain. There are a number of consequences, however, for this, which is that if I am laid off without pay for 4 weeks, then I can ask to be made redundant and get a statutory redundancy payment. Or similarly, if I have between 6 or 3 weeks, then 6 and 13 weeks, I can also ask for a statutory redundancy payment. End furlough, bring employees back on reduced hours and pay. And again, everything is possible. And as we see that gradual improvement from lockdown and we're trying to ease in trading, this could be attractive. Key point again, of course, is needs to be done with agreement. I would also suggest that we describe that as a permanent change, but one which is reviewable. Some clients have preferred to deal with it on a far more short-term basis. I think the only issue with, say, agreeing it for 2 months is that at the end of the 2 months, are you really going to know that much more than you know now? And you would need to go through the process again. But certainly food for thought. I think you also have to consider your collective and individual consultation obligations. Again, we come back to the magic 20. Even if it's an alternative to redundancy, if we are simply putting it forward as a proposal, then arguably the collective obligations don't trigger, because we're not anticipating making more or 20 people lose their jobs. Individual consultation, however, is extremely important, and I'm very happy to answer any questions about the ideas and the experience we've had so far on how do you deal with collective consultation in an environment where individuals are not at work and may have variable, shall we say, IT skills and indeed equipment. And again, if we look at the contractual short-term working provisions, does your contract have this provision? Because clearly, if it does, then that's something you could seek to utilise. Again, the catch here is 50%. 50% or less in terms of pay, then you're likely to fall foul of the provisions in terms of the right to claim a statutory redundancy payment. So where we've seen clients move down this track, they have tended to stick very heavily at the 3 days a week working and 2 days off. So a 40% reduction effectively in salary. Now this slide I apologise for because it was included by my teenage son who, when I rehearsed this, said it was so boring I needed a joke. So yes, if you'll forgive me. I would love to know how she looks quite so perfect in all of these pictures. Thank goodness we don't have video because you would know exactly what I mean. Yeah, this I think is going to be quite tricky. We go back to that very first slide, we talked about British Airways and their ability to persuade their pilots to take a 50% pay cut. 50% is quite drastic, but we've certainly seen a range of between 5, 10 and 15%. There is, of course, a catch. If I'm furloughed on 80% and do nothing, it's quite difficult to agree a variance with my staff who are actually working, which means that they are really not substantively better off. So that's, again, an unexpected consequence, I would suggest, of furlough. Again, we need to obtain the agreement. Likely to need to include some type of review period. One could not rely, for the sake of argument, upon those standard provisions which we use in pretty much all contracts, which talk about, informing you of a change. Informing someone of a change, i.e. a pay rise, is one thing. Informing somebody of a reduction of, say, 15% is something else altogether. Need to be very clear as well as to what is the impact of this reduction in pay, be it temporary or indeed permanent. And the areas where we've looked at particular concern are things such as impact on their pensions, a question about salary sacrifice, does that work? We know that HMRC said that this is an occurrence which could mean somebody could opt out of the salary sacrifice scheme, whereby they artificially, as it were, reduce their salary in terms of pension. What happens in terms of notice? We think now that notice periods should be on the old pre-reduced salary. Also, when we furloughed somebody, so we've done 80% of normal, we tend to implement the pay cut when they come off furlough at some point in the future. However, it is a bit of an unknown point as whether or not that's good practice or whether or not that's actually a requirement. Other issues as well are life assurance. Are we talking about 4 times the furloughed salary? Are we talking about 4 times the normal, i.e. pre-furlough, pre-everything else salary? Or are we talking about this new reduced salary? Something to check with your insurers, because clearly a number of individuals rely on the assurance in these difficult times, particularly to support things like mortgages. And so again, if we look at collective and individual consultation obligations, I think you're far more likely to run into a collective consultation issue when you are trying to bring staff back on reduced pay in the same hours. I also think you're likely to find there is a higher level of resilience and indeed resistance. So something to bear in mind. Again, I think we can probably talk about that in the questions, but it's something very much to keep at front of mind, this whole parallel, collective, and indeed individual consultation. I love this one, unpaid or part-time leave or sabbaticals. In the last recession, because some of us are old enough to remember that, in 2008, this was incredibly popular. I think the popularity of it in the present context, where nobody can really leave the end of their street, is probably a lot less attractive than somebody who go backpacking around Asia. But I think I put it in because there will be some people who will be looking for a change to part-time leave and sabbaticals. I think we've seen a particular crisis, difficulty in relation to people with children who are not at school, particularly younger children, which has really impacted on their ability to work full-time. So they would probably prefer to go part-time for a finite period. Key point is we can't impose it. I'm not that keen on encouraging it either. I think it's perfectly okay to invite requests. We obviously have to retain the right to decline for key workers. Always a classic problem here. It's a bit like volunteers for redundancy. If I refuse your request, then it looks as though I'm being punished for being good. Therefore, what is the incentive for being good? So I think just something to bear in mind. Again, very important about agreeing the terms of the sabbatical. Need obviously written consent. But some of the issues I think for the sabbatical are, one is about duration and what happens at the end of the sabbatical, because the intention or the hope would be that everything will be more normal, whatever that new normal is. Of course, in practice, that may not be the case. And therefore, I think it's quite important to be clear that we will obviously look for a suitable role at the end, but that may not be possible. That may, of course, again, preclude or off-put people from applying for it in the first place. Some people, however, may still wish to pursue that. So I think it's worth putting it into the pot, as it were. Now, as I think I've already hinted, I suspect that this may very well be the main output, which is the headcount reductions. And I flagged up on the slide some of the key points to bear in mind, because obviously this is not a talk per se about redundancies. But I think it's very important if we look at this 20 or more proposed redundancies in a 90-day period. And so, for example, if I lose individuals because they don't want to sign up to a pay cut, then they would count towards these 20 potentially. It's not just pure redundancies. If I don't agree a pay cut, then I may still be dismissed, but I may not be entitled to a statutory redundancy payment. So rather unhelpfully, there are slightly different definitions, which is why if you think you are likely to be looking at 20 or more, or probably I would say from about 16 or 17 or more onwards, you need to really consider this collective consultation process. Collective consultation is a whole new procedure. There's specific legislation surrounding it, and we're talking about collecting with either recognised unions or more likely, I suspect in our context, with what we call elected employee reps. And again, that is an area that I'm very happy to take questions on, because how we would consult on redundancies during furlough, I think has been a point of some interest. And we know now that you can collectively consult on redundancies during furlough. Next point is 20 or more at one establishment. So we can argue that each shop is its own establishment. We know from some of the case law, some of you remember the BHS collapse, that bigger shops were seen as establishments, smaller satellite shops were really grouped together to be one establishment. So again, each case on its own merits. But one can imagine a scenario where the manufacturing plant would be one establishment, the centralised head office function, albeit on the same site in a different building, could be a separate establishment. Shops could be a separate establishment again. So again, I flagged up this special circumstances defence. We look at the 30-day or the 45-day consultation period, or such other consultation as is reasonable. So if a business is, let's say, on the brink of bankruptcy, it might be thought that a lower, shorter period than 30 days would be appropriate. And this is what we call the special circumstances defence. Unfortunately, COVID-19 might have many, many consequences, but it is not in itself a special circumstances defence. I think it's fair to say as well, though, for the reasons I've just hinted at in terms of the practicalities of consulting over this period, that in fact a slightly longer period might very well be required than would be the case if everybody, say, was actually in the particular same building doing their same things, which is much, much easier. And then the final point I've raised on the slide is the obligation to file a HR1 form. This is a government form which is submitted to the government department. You can submit it online, and it applies to all redundancies, 20 or more. And it needs to be done, let's say it's 20, so 30 days before the first of those dismissals takes effect. Even if you end up only losing 15 or 16 people, you should still file the 20 if at your beginning point that's what you think it might be. Very important to do this. Again, we know there's no COVID-19 defence, and a failure to comply effectively results in a limited fine. And if any of you need to persuade some of your senior directors, basically up to a prison sentence for company officers. In several years of doing this job, I've never heard of anybody going to prison because they didn't file a HR1 form. However, it is something which is easy to overlook. And in these slightly more febrile environment, I think we should make sure that we always remember to flag that into our timescale. So at the point we start collective consultation with the prescribed information, what we call the Section 188 letter, at that point we should also file our HR1 form. And I'm happy again to take any questions about that. I've already touched on this really, consultation during furlough. The government announced on Friday that if I am a trade union representative and I'm furloughed, I am still entitled to participate in consultation, represent individuals in grievances and disciplinaries, and that does not count as work. So I think it's pretty apparent that there will be consultation during furlough. I think it's a matter of some discussion about the extent to which you start the consultation or indeed conclude it, and you wait to the end of furlough whenever that happens to be. I don't think there is necessarily a right or a wrong answer to that, but I think it's something which needs to be given some careful thought. We are in very unknown terms and very uncertain times, which is why some of the other solutions, shorter redundancy, I think are probably worth considering. If we assume that consultation at the end of furlough, let's say we know the scheme is going to go on to the 30th of June, then consultation can start on the 1st of July, and the earliest date those redundancies could take effect would either be the 1st of August or the 16th of August, depending upon the numbers. So if you're working out your plan, you can see how that would work out. Obviously, if you decide to consult during furlough, then you'll be looking at starting consultation if you're looking at 45 days, probably in the middle of May, which is why I think we will see an announcement probably in the next few days. So, notice periods during furlough, payment in lieu of notice. This is still a bit controversial. If I complete my consultation whilst the individual is furloughed and they're entitled to an additional period of notice, can that notice be worked on furlough? So can I get an 80% contribution from government to cover that? That is an unknown. I think the preferred view at the moment is that notice is a pre-existing obligation. You would have had to pay it anyway, should you terminate, and therefore not appropriate to claim it back effectively under the COVID-19 scheme. But we still don't know. Obviously, if you're going to pay in lieu of notice, that's a lot more straightforward. Payments in lieu of notice are effectively normal payments at normal pre-furlough salary. Then the last thing I wanted just to touch on was what I've called multi-jurisdictional redundancy exercises. We have a number of clients who have a number of different sites, particularly on mainland Europe, and that raises some serious issues in coordination terms. Generally speaking, other EU countries, they have a far more draconian, I would say, and certainly far lengthier consultation process. As a minimum, you might be looking at talking to your European Works Council, and it seems quite clear that the whole process itself will take a lot longer. So something, again, to factor into when you're making your timetable. Yeah, and finally, I thought there were just some other things that we needed to consider now. The key point is that as of the 6th of April, the new cap on a week's pay went up to £538. So maximum statutory redundancy pay of somebody who was over 41 and had done 20 plus years is 16,140. Key point is that this cap does not apply to notice pay. That's on actual pay. Again, new changes in terms of the 30k tax-free severance. Historically, there was a saving to the employer in that national insurance contributions were not deductible on the excess over the 30, so the taxable element. That was obviously just too good to be true. So after 3 years of putting it off, they've now agreed that there would be an additional national insurance contribution. It's worth knowing what that is because it can be quite significant and also may colour the amount of non-contractual termination payment which is actually paid. I think people tended to pay slightly more because they passed on the saving, and now that saving is no longer there. Third point is this whole question, which is already becoming a bit vexed for some of our clients, about the carryover of annual leave entitlement. If we look at the guidance, and indeed the Treasury notes as well, we talk about carrying over annual leave for up to 2 years where linked with COVID-19. I think it is important to say that our understanding at the moment is that you can enforce holiday during furlough, but you need to give the maximum amount of twice the notice. So if somebody wants to take 2 days, you've got to give them 4 days notice that they need to take that time off. Holidays obviously on full pay. And again, question then is whether or not you will be simply topping up the additional 20%. Possibly more if you were looking at a high earner. So again, an area which I think we'll see quite a lot of hangover as individuals deal with these sorts of queries. And you'll see in the popular press, there have been a lot of articles this week on how individuals should be treated in relation to bank holidays, for example, and carrying those over. Final points to consider are reviewing home working and associated health and safety policies. We hold our hands up here, certainly I do as in our business. We moved to home working within about 48 hours. Our home working policies, particularly in terms of health and safety, had been somewhat generic. I think this is the moment to look at those. And I know in the questions, there are some specific discussion points about the extent to which we have a split between home and office space, and I'll talk a bit about those. But if you don't have a home working policy, and you haven't really thought about the sort of risk assessments that you need in equipment, then this is probably something else that you need to consider. And finally, and I'm conscious this makes me sound a bit miserable, I think a number of clients are considering the reintroduction of statutory layoff provisions in contracts of employment. There was a question about future-proofing. I think the only thing one can do is to reintroduce this type of provision, of course, with consent. And we don't know whether this furlough scheme will ever occur. Hopefully nothing like this will ever occur again. But I think it's something to consider, and again would need to be introduced by consent. So that's a sort of whistle stop through what I think some of the options are. We go on to the next slide. I think Cressida's got some questions.
Yes, thank you. Some fantastic and interesting content there. Thank you, Catherine. So now on to the next part, the question and answer session. So I've collated some questions from our participants, which I'll now put to Catherine. I think some bits were covered, but if I repeat them, you might want to just recap or add additional bits to them. So the first question, the initial furlough period had to be for a minimum of 3 weeks. After this, does it need to be extended by an additional 3 weeks and therefore keeps rolling on a 3-week basis for as long as needed? Or can it be extended on a week-by-week basis after that initial period?
Our understanding is that the minimum amount of time you can be furloughed is 3 weeks. So the example I gave was where somebody was required for a day. I've got another client where somebody's been required to come back in a week to do some maintenance on a gym and leisure facility. You're furloughed for 3 weeks. You then are de-designated as furloughed and come back in and you work normally. You're then re-designated. But as I understand it, every period has to be for 3 weeks. So even if you bring them back for 2 weeks and then they need to come back in again, you will end up paying effectively for the full 3 weeks. So the 2 weeks on the new furlough and indeed the additional week. I'm not quite sure what the magic of this 3 weeks was. I think a lot of it was just simply ease and convenience. And what they didn't want to do was have lots of people flitting back and forward, creating an extra burden. But I think the answer is yes, initial period has to be for 3 weeks. no, you can't extend it on a week-by-week basis.
Okay, thank you. So a few questions looking at options open to us post the immediate COVID-19 lockdown as restrictions begin to be lifted. So firstly, if we get to a position post the full lockdown where employees are asked to go back into the office before companies actually require them to do so, what information and indemnity should we be looking to have in place to protect ourselves from any form of vicarious liability?
I think this is incredibly difficult. I think the start point is that employers are vicariously liable for the negligence of their employees, and they're also liable for health and safety of work and a safe place of work. So if you don't believe you can keep your staff safe, which is your judgment as an employer, then you can't let them come back, even if they want to come back. You can ask for an indemnity, but as a matter of common law, in fact, you can't indemnify, the indemnify is somebody against personal injury is pretty meaningless. So I think the key point is to understand why they want to come back. If you allow them to come back, you allow them to come back at their own risk. I think it's very important that you do some very, very careful risk assessments as to how you could accommodate them and minimise that risk. I do think that the furlough scheme has effectively avoided some of these difficult questions, because I think there was a big, stronger push to come back when people were effectively social distancing because of family members being in one of the high-risk groups and were only paid statutory sick pay. So that was particularly attractive. But I think actually part of the point of furlough was to get around some of that. Now we know the furlough is coming to an end, however, I think we're going to see more of these queries. I think we're going to have to take a very careful look at such requests, bearing in mind that effectively you will be taking on the liability. And again, I couldn't stress it enough, if you don't feel that you can keep them safe at work, then you've got to order them to stay at home. If they refuse to stay at home, then that's a failure to comply with a reasonable instruction.
Okay. Once we begin the phased return to working in the office, are employers responsible for the journey to work, e.g. providing masks, or just putting in place the relevant protocols and tools for social distancing, hygiene and sanitisation in the office itself?
I think that, it's pretty clear that generally speaking, if we look at the working time regulations of recorded day, travelling to work from home and from work to home is not considered working time. And therefore, it would seem that as we owe the duty in working time, then you're not responsible in terms of their return to work. And so then you would just be responsible for putting in place the relevant protocols and tools for the social distancing. You might very well, however, offer slightly different provisions. So, for example, client car parking could be offered to staff, might assist somebody who perhaps wouldn't then have to use public transport. But I think the general view, and I think we will get some more clarity on this when we look at the lockdown, is we may not be responsible for it, such as the provision of masks, but we clearly have to be mindful of it in terms of the practicalities of getting people back.
Brilliant. In the event of us shifting to a part office and part home working arrangement for the future, what consultation is required? Also, is it recommended that we make it contractual or not?
Yeah, the big starting point with all of this is, what does your existing contract say? So if the existing contract says that your normal place of work will be X, but you may be required to work in other locations, then the argument goes that actually you don't need to change the contract because you've already got the right to insist that they work from home. I'm a bit of a consensus builder, so I think that almost always needs to be some type of consultation, and it needs to be done by some type of agreement. But I think the start point is definitely the contract. If in doubt, however, then clearly that sort of change in location could be a contractual change, and is certainly something you would need to document. We need to look at whether or not there is this flexibility in the contract. If there isn't, then ultimately you might need to go down the collective consultation, dismissal and rehiring route. I think that is a long way down the track, however. And as I say, I think the start point is to see what you can do with agreement, and particularly look at how strong your hand is by what flexibility you've got in your contract.
Okay. And a few questions now around the updates to the contracts on the 6th of April and points to consider when reviewing. So what evidence can an employer ask from those that are shielding or regarded as extremely vulnerable, and those that are at high risk due to their health conditions, e.g. NHS letter, email from GP, prescription. What are we looking at here? And are companies paying full pay, reduced pay, or sick leave to employees in these categories?
I think lots of questions in that.
Yeah, there is.
That is a lot. I think there are lots of different types of individuals. There's the extremely vulnerable individuals who were told that they would basically have to self-isolate for about 12 weeks. They will have received a formal letter on or about the 25th of March onwards. So and all those letters will have been in circulation. I think the last ones went out 5 or 6 weeks ago. So that letter is there, and clearly an individual can produce the letter. I think the question is, I mean, the letter itself is a bit of, you could photocopy it. It's quite easy to, dare I say, if you're minded to, it's not particularly fraud proof, if you like. I think you could look for some declaration from the individual. Normally, we would say, of course, getting a letter from the doctor to confirm what the health conditions are. We're never going to be able to get a letter. So I think we're going to have to take a view. So if you know that an individual has had ongoing cancer treatment for the last year, it's pretty safe to assume that they're probably going to have received one of these letters. So I think it's looking at the other surrounding evidence. I think it's looking to see what you can get. But I do think it has raised some issues. I think a number of those individuals who cannot work from home have in fact been furloughed, and the furloughing has effectively avoided some of these more tricky questions. I think it's pretty apparent that certainly they're entitled to statutory sick pay. I think for those clients where they have a contractual sick pay, and most people seem to have some sort of element of contractual, albeit discretion, they have exercised that discretion, but made it pretty clear that this was not infinite. As I say, I think fortunately we are already well through that 12-week period, and therefore by the end of the furlough, probably the 12 weeks will have evaporated anyway. Now, clearly, if they say to these individuals that they cannot go back to work even after the 12 weeks, then I think we will see some very tricky questions. And I know there's a question later on about what are the options in relation to those people. If you can't work for 7 days because you've got COVID-19, you can get an isolation note through the online service, which clearly would give good evidence. Similarly, for the first 7 days off, they can self-certify so that they don't need that evidence. But I think it is a very hard, it's a very tricky decision because, as I say, the documentation issued by government is eminently copyable. Wouldn't dream to suggest that I've copied it, but having seen it, it is very easy to replicate it. Mm-hmm. So I think there will be some issues. I'm sure some of you may have seen that ACRES have just issued a guidance note actually about how you do disciplinaries and grievances in this tricky time. They issued it earlier this week. In fact, I think we're about to do an article on it probably today or tomorrow. And certainly, I think there will be a number of fraudulent claims. And indeed, I'm sure there will be some disciplinaries as a result. So I think it's a watch this space, but it's very good to be mindful and also to be aware of what you're looking for and what you're asking for.
Okay. Another good question. For those employees who are self-isolating for 12 weeks and due to the nature of their job, they cannot work from home, at the end of the 12 weeks, if COVID-19 is ongoing, could companies consider making the employee redundant if there is no known date to return? Would this be deemed as discriminatory, as the reason they cannot come into work is due to their health condition? The work is still there, but it's being absorbed by others who can come into work.
I think this is going to be a very difficult area. I mean, clearly we know that, for example, if we look at the sort of disability or pregnancy or a health condition, they're all protected characteristics. The day one right, so it doesn't matter how long they've worked for the employer. And it certainly could be unlawful discrimination for them to be dismissed in the circumstances you take. But if we look, for example, at the disability point, we're looking at what reasonable adjustments could be made. And it seems to me that if they could not do their role at home and they cannot, an employer is entitled to have an individual who works for them and actually carries out a role, then in that limited number of examples, they potentially could be made redundant. I think it would be very difficult because this is not going to be an infinite non-attendance. And as I say, I think it's likely to come to an end fairly quickly. But I think it's possible that they could be dismissed. However, I do think there's quite a strong risk I certainly think as well there's a risk if the employer tries to pressurise them, as I've seen some examples, individuals to go into work, or unreasonably disciplines them because they think they're swinging the leg, as it were. So I think this is a very problematic area. I think it's possible they could consider it. I think it would be quite high risk. Certainly the maternity, I think, will be very high risk because, as by its nature, they're not pregnant forever. So I think that would be very difficult.
Okay. So finally, the last question on this section, one of our clients has some colleagues who work for them but are based at their client's premises. They're currently furloughed but are concerned about going back to the workplace due to the number of colleagues based there and whether the client can responsibly facilitate social distancing. The question is, if a colleague is asked to return from furlough to the workplace, but they do not feel safe to do so, are there any legal grounds for them to refuse? Would our client need to look at home working, or would they reserve the right to say that this is a reasonable management request?
Again, I think very difficult. The bottom line is the employees who tell you that they won't come to work because they consider it too risky can be protected, because there's protection against people as whistleblowers, and there's also other specific legislation protecting those who think that they're in danger that is serious and imminent. It does depend on government guidance. I mean, obviously the start point at the moment is that if the employee can perform the duties from home, then that's what they should be doing. I think when they're working off-site, as it were, then it is a question of you looking to see what provisions and protection the client, if you like, has put in place, and looking at their risk assessment and taking a view. And if you're satisfied that it is a safe workplace and that the proposals, let's say the reduced number of staff on site, is fair, then you can expect the individuals to come into work, and that would be a reasonable management request. However, I think there would need to be some good consultation. And also, I think it's very important that you have all the documentation, particularly the risk assessments from the client as to what they have done on site. And because I think you would be effectively relying on those, albeit you can't delegate your primary obligations in terms of health and safety.
Perfect. Thank you.
All right.
I am just looking on the Q&A section, and there are a couple of questions that have come up. So now's the opportunity, if you haven't, anyone out there, to put a question to Catherine while I go through these two. Actually, the first question is probably covered. If we furloughed initial 3 weeks, do we need agreement to extend for the further 3 weeks? Yeah, I think we've pretty much covered with that one. The next one, if someone resigns and is on an agreed temporary salary reduction, should this be on the reduced salary or their full salary? I think we did cover that, didn't we?
Yeah, I think we did cover that. I think our take at the moment, we're not totally sure. The guidance is not clear. So what we're saying there is that our view is that the salary for notice should be on normal, i.e. pre-furlough salary, so 100%. But there is a grey area with that. But our general view is we should be looking for the 100, the normal salary. There is a question, though, about whether or not, of course, you're only paying the 20% top-up, because if they're furloughed while they're working their notice, so-called, then they're getting the 80% from government. And that, again, is a grey area, but I know a number of individuals are exploring that because it's obviously quite a significant cash saving.
Okay, so I don't think there's any more questions at this stage. So I'm sure everyone will join me in thanking Catherine. Really helpful guidance and advice provided today. Delighted to have you this morning. I love the way that you can still bring humour into all of this situation. So thank you everyone else for joining us today. Hope you've benefited from this and hope you all stay safe, healthy and positive, and look forward to working with you in some brighter times.